about is people will come to me and said, we already signed a contract. The doctor doesn't like what he's getting reimbursed. He thinks it's too low. Well, unfortunately, because he's already signed that contract, he's agreed to it, and there's nothing I can do to try to change it other than the doctor tried to renegotiate with the insurance company, but they're going to say no. They've already worked very hard to get to this agreement, so they're going to move on. You got the non-contracted doctor. This doctor has not agreed to a contract at all. Therefore, when the doctor sends his claim to the insurance company, he's expecting to get paid at least 100% of what his charges are. Now, we all know the insurance companies don't do that. I got a letter from an insurance company I won't name, which basically said they have created a policy for non-par providers. So what they said is, we're going to start paying all non-par providers this percentage of what the Medicare allowable is. So that's when I went back and talked to the insurance company and said, we aren't agreeing to this, because what you're doing is you are forcing a contract down our throat. You're telling us we have to agree to this payment plan that you've come up with, and we have to accept it, and we don't have to accept this. They said, well, yes, you do, and we're going to enforce this on your contract. Till finally I said, you know what? I'm going to find another way to try to overcome this. And I did find a way, and I found the way through ERISA. And again, I mentioned that earlier. I'm going to mention again in a slide in a little bit from here. So this is what it looks like at 25%. You can see for a level 1 visit, they're going to pay us $2.33. Very, very low. Level 2, $6.04, all the way up. $28 for a level 5 visit, which basically the patient is pretty much on death's door. Several things seriously wrong with that patient. He's going to get paid $28. He can make more money serving French fries at Burger King. So that's what you want to try to do. When you have a non-contracted provider and they're paying you less than what they're supposed to pay you, you need to fight back. As Don says, never give up, never surrender. State law. You have to see if you have a state law when it comes to how much a doctor is going to be in risk. For example, this is my state law here in the state of Florida. They basically said that when you bill an HMO, you're going to get paid either the lesser of the provider charges, which the insurance company has even gone to court and told the court the provider charges to us is what we have agreed to pay that doctor. And the court said, okay, well, to me, the provider charges is the amount that the doctor charges for that particular visit. Or the law says that the doctor get paid the usual and customary provider charges, or a charge mutually agreed to between the HMO and the doctor within 60 days of submission of the claim. They have never gone to Part C right here. So what I try to do is get the doctor paid what he's supposed to be paid. Usual and customary has been fought here in Florida for like 20 plus years. They have never come up with an agreement as far as what usual and customary is. And the insurance company won't say exactly what it is. So if they're paying my doctor less than what they're supposed to be paying, state law, they're going to use that state law to try to fight back. But I'm going to go even further than that. I'm going to use ERISA to fight back, which takes us now from going from the insurance responsibility to patient responsibility. At some time, this is going to happen. No matter what type of insurance we have, it's going to go from insurance to patient responsibility. With Medicare, I have a 20% co-insurance that I'm responsible to pay for, plus my deductibles and co-insurance, but I don't have co-pays. So at some point, I'm going to get a bill. The question that we have to ask ourselves, do we balance bill the patient or do we not balance bill the patient? In some cases, the insurance company is going to use state law to do this. And in my state, we have 641-3154. Basically says that as long as the HMO accepts responsibility for the claim, we're not allowed to go after the patient, period. This is what I call Florida's no balance billing law. But I found a loophole with this law in ERISA, which I'm going to talk about in a minute here, federal law. But again, the insurance company is going to say, we want to use state law to pay you. I'm saying, no, 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 you cannot do that. As you can see here, this is from my personal health benefit manual. It says that the doctor may bill the customer or the patient the difference between the healthcare professional's normal charge and the maximum reimbursable charges determined by the insurance company, in addition to co-pays, deductibles, and co-insurance. So basically, ERISA says I'm permitted to balance bill the patient. The insurance company is going to come back and say, no, you cannot do that. They're going to say you have to use state law. You cannot use state law because state law prohibits balance billing. So you know what? This brings us to this question. Do I follow ERISA or do I follow state law? That's a good question. I asked myself this question. You know what? I experimented by using ERISA, by balance billing the patient. That's when the HMOs went crazy, running up and down the street going, citizens arrest. Remember that old Andy Griffith TV show where Gomer Pyle was yelling at Barney Fife for making an illegal U-turn? This is how they are. They're like chickens with their legs cut off, screaming and running around saying, you cannot do this. But you know what? I looked at ERISA and I said, you know what? ERISA says I'm permitted to balance bill this patient, and I did. So again, they went screaming. They filed a complaint with the state of Florida. The state of Florida sent a letter to my doctor saying, we've received a complaint that you may be in violation of state law. If we investigate this and we've determined that you have violated state law, we may revoke your license to practice medicine. So if you're a doctor, you get a letter that says that you may lose your license to practice medicine, you're going to go crazy too. But I talked to my doctor. I said, you know what? This is what ERISA says. These are ERISA health plans. We've already balance billed the patient. This is what my response is going to be to the state if they file a complaint against us. So you know what? I sent the thing to the state of Florida. They dropped the investigation because I proved to them that I was right, that ERISA basically was in charge, and we were not in violation of state law by balance billing the patient. Why is that? Because this part of ERISA law, 29 U.S.C. 18 section 1144 subparagraph A, it basically states is if the health benefit plan is under ERISA jurisdiction, then ERISA supersedes any and all state laws. This is very important to use. This is what I use to fight back. And as you see on the slide here, it says the insurance companies know about this federal law. Because what happened was there were two patients, both from the state of Texas, that went to the state court in Texas to file a lawsuit against their HMOs. One of them for denying them medical care, the other one for changing the medical care that they were supposed to receive. So the insurance company said, you cannot sue us in state court. So they decided to go to the Supreme Court and said, Supreme Court, ERISA says that state laws are superseded. Therefore, these people cannot sue us in state court. Plus, any state law that says they can do this is superseded by ERISA. The Supreme Court said, yep, you're right. So then these people are now running up and down the street yelling, hooray, whippy, the Supreme Court found in our favor. But you know what? It backfired them. Now we could use the same ERISA law against them. When they tell me I can't balance bill my patient because I got a state law that says I can't balance bill the patient, I'm now using the same thing against them, and they don't like that. That's how I was able to fight that letter that the insurance company got me. So I said to my doctor, let's balance bill 5 patients and see what happens. Sure enough, they did exactly what I said they would do. I got those complaints dropped, and now they came back to us and said, you know what? Let's have a meeting. We walk into that meeting. We've got this long wooden table and all these people in gray suits on the other side. All their lawyers are sitting in that room. I'm walking in with blue jeans and a pullover shirt. They told me I was very disrespectful to them, but you know what? I didn't care. I'm there to get my doctor what he's supposed to get. We finally sat down and came up with a settlement. My doctor got paid a 6-figure settlement out of that deal. When they said, you know what, let's forget about ERISA during this meeting right here. And I said, no problem. Just write the check and I'll forget about it. But they know all about this law right here that says you are permitted to balance bill the patient. Now, incorrect insurance payments. Sometimes they don't pay us correctly. You saw that check for a penny. So what happens when they do that? We've got to dispute that incorrect payment. That's what our job is. That's what my job is. That's why Don says Steve never gives up, because I go after them with a vengeance, and I don't give up. I show the insurance company that I'm right and that they are wrong. And when I send any dispute to them, again, I don't call them appeals. Whenever I send a dispute, I send everything by certified mail, return receipt requested. Why do I do that? Because the one thing I don't want to hear is, we never got it. And they're very famous for saying, we never got it. And if I try to file a complaint with the state regulators, all they have to say is, I never got it. And it's their word against mine, unless I've got something that shows they're wrong and I'm right. That's where the certified mail comes into play. I can in turn file a complaint with the state of Florida showing the certified mail return receipt. Now the state of Florida can go after the insurance company. They can say, we never got it, and then they're going to wave this piece of paper in front of them saying, yeah, you did. So where did it go? Now they're going to call me, the insurance company's going to call me up and say, let's have a meeting. And by the time I walk out of that meeting, I'm going to walk out of that meeting with a check. But you dispute all incorrect insurance payments, and you don't give up until they give in. It's that simple. The patient, this is a side of the patient that you really don't want to see. I see this a lot. That's not me, actually, by the way. But this is a side of the patient you want to. Again, we have to go from insurance responsibility to patient responsibility at some time. There are two types of patient collections that I call. I call it an uninsured patient collection and a self-pay patient collection. I'm going to describe what those are in a minute here. The first one is the uninsured patient. This is someone, they have no health insurance whatsoever. Therefore, they have to pay for their health care themselves. I know we have the PPACA, Patient Protection and Active Care Act, otherwise known as Obamacare, which basically said everybody has to have insurance by this time in 2016. But let's say they worked for an employer who got them insurance, but the employer went out of business, and the patient can't afford to upkeep with the cost of the insurance. So now the insurance has dropped. So now you've got this patient who doesn't have insurance anymore. So they may come to you. So that's what I call an uninsured patient. They're going to have to pay for it themselves out of their own pocket. The self-pay patient is someone who has insurance, but at some point the insurance company has transferred the payment responsibility to that patient for co-pays, their deductibles, their co-insurance, and for denied claims. So that's why I have the difference in the two. So the doctor may come up to me, can you give me a demographic of what my practice looks like with uninsured patients or patients who have self-pay? Because maybe he wants to meet with the insurance company, ABC Insurance. He may say, how many ABC Insurance patients do I have that are self-pay? So he can go into that and say, look, I saw 10,000 of your patients last year. You transferred payment responsibility to your patients and they're not paying. I want to receive a larger increment in reimbursement because of that to offset my losses. When he's trying to negotiate an insurance contract with them, this is going to be very, very important for that doctor. So he wants to know how many self-pay and how many uninsured he has. So an uninsured patient, they have no insurance whatsoever. You want to establish a practice financial plan to discuss this with that uninsured patient when they walk into your practice. You want to know about a practice financial plan, contact Jennifer Wilkes, and I'll come up with that, with an article about that, or I'll come up with a presentation about that. But that's very, very important to do. When they walk into your office, here's our practice financial plan, Mr. Verno. This plan talks about insurance, about sending a claim to your insurance company. This practice financial plan talks about your co-pays, your deductibles, your co-insurance, and what happens if the claim is denied, whether or not we require you to appear or how we can assist you with the appeal of that denial. It talks about time payment plans. If you want to set up a time payment plan, Mr. Verno, you owe us $300. How long do you think it's going to take you to pay back that $300? I'll say 300 months. But if you ask a patient, how much do you think you could pay each month, they're going to tell you $5. But be very careful when you say, how long is it going to take you to pay this? $300. 300 months? Well, you asked them that question, they gave you that answer. So see that you sign a time payment plan agreement with them, and that they stick to that time payment agreements. Now, can you give an uninsured patient a discount? Yes, you can. Now, what I did here is on this slide, I've listed down the web address for the Office of Inspector General. What they did is they came up with a paper that talks about whether or not you can give an uninsured patient a discount. And yes, you can do that. Best thing to do is make sure you've got that discount in writing and you've got it located in the patient's medical record. But you can give them whatever type of discount you want to. We're talking uninsured. We're not talking about patients who have insurance and they got a responsibility to pay for their copay, deductible, and co-insurance. You could probably do that, but not on a routine basis, and I've got that covered later on in the presentation here. Let's look at the next one. Again, the self-pay patient, the insurance company has paid. Now you got to talk about their copay, which is usually due at the time of service. Whether you're collecting that or not, I don't know. I can go into a practice, there could be like 50 million signs up on the wall. Half of them say payment is due at time of service. So when I check out, they don't ask me for anything. So I'm asking myself, are they really sticking to their payment plan? And then they wonder why they're not making any money, why they have to contact an expert to come in to try to help them out. So if you have a sign that says copayment is due at the time of service, and collect it. Don't go up to the patient and try to fool the patient, because your patient probably knows whether or not they got a copay or not. And copays are probably no longer $15. My son has a copayment of $500 that he has to pay at the time of service. So he has a credit card specifically designed for that visit. Deductibles. A lot of times we have to try to collect the deductible from the patient. It may take a patient a whole year today to pay their deductible, because I've seen some copays that are like deductibles that are like $10,000. They aren't cheap anymore. The purpose is so that the insurance company doesn't have to pay anything out of their pocket anymore. They're transferring payment responsibility to the patient. And you know what? The patient's angry. I had a woman say, Steve, I'm paying all this money with insurance premiums. Why do I have to pay more money out of my pocket? I said, you need to ask your insurance company that question. Don't ask me that question. My responsibility is to collect these co-pays, deductibles, and your co-insurance. Some people have secondary insurance, which will help with the co-insurance. I'm lucky enough right now to have a secondary insurance that pays my co-pays, that pays my deductibles, and pays my co-insurance. So I have no out-of-pocket expenses now with my current insurance plans. You want to talk about discounts to your patient? Have a discount policy in your practice financial plan. Talk to your patient about appeals or disputes. If you want to help them, that's fine, but make sure that you've got everything you need to do this correctly. The biggest complaint I hear is, Steve, the insurance company didn't pay the claim correctly. We need to appeal this, but the patient has the EOB and they won't send us a copy of it. What can we do? I said, simple. Send the patient a letter saying, until they send you that EOB, they're going to be responsible to pay this medical bill. And you'd be amazed how fast that they will send you that EOB. I'm not saying send them a statement. Send them a nice letter, letting them know that you want to help them, but these are the conditions that you have to set so that you can help them. Debt collection. This is the seedy side of our business. This is what I call it. We don't like sending patients to debt collection. I don't like it when I'm sent to debt collection when that happens, because the one thing that I do, I know how the debt collection system works. And if the bill is wrong, if the debt collection agency is wrong, I'm going to fight back. You need to make sure that when you hire a debt collection agency, you follow some simple rules. One thing is that a debt collection agency should be your last resort to collect what is owed. You want to talk to your patient. You want to work with your patient to help them resolve the bill, because that's the best thing for you. Because if you're going to send these patients to debt collection agency, eventually you're not going to have any patient. They're going to find the doctor that's going to work with them. You want to do everything that's possible. Sometimes there are some people that you can't help. That's the patient who comes in for the visit and doesn't want to pay their out-of-pocket expenses, and they keep coming back and coming back and coming back, getting a higher bill and higher bill and higher bill. So these are the patients that you might want to send to your debt collection as a last resort effort. But again, try to work with your patients and help your patients out. The next thing with the debt collection agency is they're not all the same. You've got some debt collections out there that work strictly with bank debt, with mortgage debt, or credit card debt, or gambling debt, for that matter. They may not know anything about medical collections. You want to find the collection agency that knows about medical collections. There are very few that are out there. I've been through several of them till I finally found the one that I trust, and that's the one that I went with. And they are the ones that I recommend very highly. The other thing about debt collection agencies, you got to be very, very careful. They may have all the right credentials, all the right certificates, all the right badges on their window, but they may not all be the same. I went to one collection agency to meet with them. I called them up on the telephone. Are you a member of this collection association. They go, yes, we are. We're a member of this one, this one, this one, and this one. How many employees do you have working for you? We've got 100 patients that are at your beck and call that we're going to work with you. So you know what I did? I went to meet with them at their location. I showed up. The window is blackened in that you can't see through the window. When I went to open up the door was locked. I banged on the door till finally someone came up. What do you want? I says, I'm here to meet with Mr. So-and-so. Okay, hold on. They went and unlocked the door and opened it, shut it quick, and then locked the door again. When I looked inside, they had one employee at a wooden desk. That employee was the only one on the telephone, and he was swearing up and down and cursing whoever it was that was on the phone with them. So then the owner of the company come out, big old smile on his face. Here's a coffee mug for you to use with our logo on it and a whole bunch of nice little pencils or pens on it. I said, never mind. I'm not going to work with you. I'm changing my mind. We haven't signed a contract yet. So then I walked out the door. I did some more research on this company, found out they didn't have a very good track record with the state. So then I finally went to a conference and found one. They were pretty good for a little while. But then what happened is they didn't know medical debt very well. The other thing you got to make sure that they are licensed to collect in your state. I hired one where they had all the right bells and whistles, met with them. Everything looked good, but then once I signed a contract with them, they were good for a couple of months. Then all of a sudden, the checks that they wrote to us bounced. And then one day I get a phone message saying, Steve, we're sorry, but we're not working for you anymore. We're leaving the state of Florida. We're going elsewhere. They took all of our accounts with them, and all of the checks that they wrote to us bounced. We contacted the police department. Police department said there's nothing we could do about this. This is a contractual problem between you and this company. And pretty much what you did was a bad business decision. They went up, set up shop in another state, and started billing our patients. And we also got a letter from some lawyer who sent us a letter basically saying that they're using my name on letters that they're sending out to patients. I did not give them permission to use my name or use my practice. So this was a company that I thought was good that eventually turned out was bad. But from then on, I learned a lesson. I started doing a more thorough investigation with those agencies that we are till I finally found the one. As I said in the movie, that Western movie where you got the old guy pointing his finger up, there's the one where he delivered that baby calf in the desert. I think it's City Slickers, but you got to find the one that's out there. When you have a debt collection agency working for you, you want to have an ironclad contract. Get your practice attorney to develop a contract that's going to protect you in the event of anything bad that happens. You want to have the ability to remove an account because something may have happened. A patient may have slipped through the cracks. You may have had an HMO patient that somehow or another your software sent to the collection agency. Or you may have a Medicare patient that you sent to a collection agency, or even worse, a Medicaid patient that was sent to collection agency. Next thing you know, you've got all these regulatory agencies after you because you are now violating state law, and you cannot send that Medicare patient to collections when Medicare pays for the covered services. You also, again, you want the ability to remove that account. I've had some collection agencies say, no, you can't remove any accounts once you give them to us. That's not a problem. Here's your termination letter. We're firing you. We're not going to use you. You don't want to send an account to your collection agency with an insurance claim that's unpaid and has not been denied. What I did at the end of the month, when I ran the report or the file of accounts that I'm going to send to my collection agency, I sat down. I told the collection agency they were going to get the file 15 days from the date that I produced it. Why? Because I want to go through those line by line, remove the Medicaid, remove the Medicare, remove the HMOs, remove the accounts where the patient is making on-time payments. I'm not going to send anything to the collection agency that's a mistake. Also, let's say there's an account that was with the insurance company hasn't paid yet. 5 days from now, that check may come in. I don't want to give that money to the collection agency when they didn't do anything to earn it. I work that account money stays with my doctor. And that's what they're going to look for, those type of accounts. I'll talk about that in a little bit here. I put test accounts in the file that I sent to the collection agency. These were accounts with dummy names, Mr. Fox or Miss Wolf. So when I'm talking to the collection agency, they go, we talked to Miss Wolf last night. I said, no, you didn't, because Miss Wolf doesn't exist. That's what I'm saying into my head. Or I want to hear the phone call that they're making on that test account I sent to them. I want to see the statement that they sent out. I was on my way home one time when I got a phone call from the collection agency. They go, Mr. Wolf, we're going to hear to talk about the account that you have with us. I said, I don't have an account with you. By the time we were done with that phone call, they threatened to have me arrested. They threatened to have me sent to jail. They told me that they were going to garnish my wages. So the next morning, I went down to meet with them. The guy that I talked to said, no, he didn't. I said, asked to the owner, do you record all these phone calls? Yes, we do. I said, let's get out the tape and let's listen to it. And all of a sudden now that guy that talked to me, he's trying to sneak out of the office. We played the tape. Sure enough, there he is, yelling at me, swearing at me, threatening me with everything else. They looked at him and said, you're fired. I said, here's your termination letter. You're fired too. We're not going to stand for this, to have your people lie to us. The important thing is to have the payment sent to your bank. Don't have them sent to the bank that the collection agency has set up, because you may find out that they're transferring money from one account to another, or someone may be skimming off the top. That's how I found one collection agency that was embezzling against us. Because then I asked them, what's this other account? They said, we can't tell you. That's privileged information. I said, well, you're moving my money from that account, from our account to that account. I said, well, you got some explaining to do, Lucy. Have them everything sent to your bank. And again, a test account to see what their statements are like and what the phone calls are going to be like. You want to watch for cherry picking. This is where they get the accounts and they're picking all the low fruit, the easy accounts that they are probably not working. They're hoping that an insurance check will come in so they can now charge you anywhere between 25 to 50% of what has been collected. They're going to know that the insurance company paid the claim because they're contacting the insurance company and said, well, we sent a check out 2 weeks ago. Then they're going to contact me and say, where did you get this check? We want our percentage. But they didn't do anything about it. Watch for the cherry picking. They're going to pick the high dollar accounts and the ones that are easy to work. You got to make sure that the debt collection agency is not owned by the billing company. Why is that? Because very simple. If the billing company owns the debt collection company, it's easier for them to work the accounts as a debt collection agency than it is as a billing company. And they get a higher percentage as a debt collection company than they do as a billing company. This is going to be covered in the FAQ later on. Monitor every report that they send you. And when they send you these reports, take a look at them. Make sure that the accounts you said to remove have been removed. Monitor every invoice that they send you. Make sure that everything that they've got on that invoice is backed up with a credit card payment or backed up with a bank deposit. That's going on right there. Because you don't want to get an invoice for, say, $25,000 when they've got no paperwork to back up what they did to earn that $25,000. I've had them say, you don't need to know this. I said, well, yes, I do need to know this. You're not getting a check from us until I see the documentation that backs up what you say you did. They go, well, you don't need to have that. I said, no problem, then you don't need to have a check either. You want to monitor all patient complaints. That's very important. I was at the collection agency one time and a phone call came through. This woman was yelling and screaming so loud that I could hear it over the phone. And I'm pretty much deaf in one ear, but I was able to hear this woman screaming and yelling. They could hear her all the way down at Disney World. That's how loud she was screaming. She started off all nice, sickly sweet, and everything else like that. Said, can you write this bill off for me? Because I'm broke. I've got no money. My house caught fire and then drifted down the river and sank while it was still on fire. I've got nothing to pay you. Well, what they did, they were able to do a very quick credit check, found out she had a lot of money. She lived in a $3 million home. So they said, no, we're not going to give you a break. You got the money to pay for this. You got credit cards to pay for this. That's when she turned all Wicked Witch of the West on them. telling them that she's going to get them and their little dog too. So I heard her complaint. When I got back to the office, she's calling me on the phone. Again, sickly sweet. I needed an insulin shot to get over her phone call. When I refused to comply with what she wanted, that's when she turned Wicked Witch of the West on me. And then she went to the hospital to complain to the doctor that I was being mean to her and that the debt collection agency was being mean to her. But my doctor knew better. So monitor these complaints. If the complaint is valid, act on it. When you terminate the collection agency, make sure that you get all your accounts returned to you. And if they have placed any account with the credit bureau, make sure that they remove the account from the credit bureau report, because it costs money to do that. If they put them in, they have to take them out. That's my philosophy. Now, if they have you have an account that went to the collection agency and all of a sudden now, whoops, I've got insurance. The contract should specify who sends the claim. Otherwise, they're going to call you up and say, we got a call from Steve Verno. He's got Medicare. You need to send the claim to Medicare. So I send the claim to Medicare. We get paid. Now they're going to want their 25 to 50% for all the work that I just did. Make sure that this is specified in the contract when this happens, because you could have a patient with the debt collection, all of a sudden they come up with insurance. Now let me sidetrack for a minute here. We had a woman that came to Florida from the state of New York. She went and partied hardy down at South Beach. Very expensive place to visit here in the state of Florida. She went to one of our doctors to be seen. She presented herself as an uninsured patient. She filled out the insurance affidavit form saying, I have no insurance. So we sent her a bill. She didn't respond to it. We sent her a second bill. She never responded to it. We sent her a third bill, no response, and then a final notice letter, because that was the policy at that time. Then we sent her to our debt collection agency. They listed her with the credit bureau, and all of a sudden now I'm getting a letter from her lawyer. I'm getting a letter from New York State Medicaid telling me that this patient had Medicaid at the time of service and that we were now in violation of New York State law by billing a Medicaid patient. And then the lawyer said, you are now violating New York State law and Florida law for balance billing our patient when they had Medicaid. So you know what I did? I wrote to the Centers of Medicaid and Medicare Services saying, what do we do when this patient presents as uninsured patient? And all of a sudden now, after we sent them to a collection agency, they come up with insurance. So CMS wrote me a letter and saying, Mr. Verno, if this patient made a freedom of choice decision to present themselves as an uninsured patient, you have all the freedom and the right to treat this patient as an uninsured patient and continue with debt collection, basically. I still have a copy of that letter that I have scanned in and on a flash drive that I keep with me in case I need to use it. That got the HMO lawyer off our back, that got Medicaid off of my back. And when I contacted Medicaid about this, they said, well, the time limit to submit a claim has passed. I said, well, no problem. I'm going to keep billing this patient and have the patient pay. Well, once she was sent to collections, she didn't care anymore, because at some point, the collection agency is going to stop collecting on these accounts. They're going to go off into limbo. You got to make sure this collection agency continues to follow up on all of these claims, not just the ones that they want to cherry pick. The important thing is that the collection agency works for you, not the other way around. I've had collection agencies come to me at my office and tell me what I'm going to do, tell the doctor what he's going to do. They said, no. You work for us. You work for us based on a contract. I don't work for you. This is our policy, and this is the policy that you will have to follow. They didn't like that, no problem. There's another collection agency just around the corner that we could hire if you don't like that. So that's very important, that they work for you, not the other way around. When you use a collection agency, understand that you've got to pay them a fee. Usually it's anywhere between 25 to 50% of what they collect. It could go even higher. It's very important that you understand how much you're going to give up when you're going to sign a contract with the insurance company. Now, looking at the slide, there's a little hint here about the collection agency that I trust. I'm not going to say who it is, but you can see for yourself what it looks like. I trust these people that are in this slide right here. They're good at what they do. But again, you got to pay them a fee. You got to make sure that if you're going to pay them this fee, that they work on those accounts and they work hard to get you paid. Now, Before you send these accounts to your collection agency, screen them. Again, if you've got a claim that's been unpaid, go through and remove that account from the file you give to the collection agency. If it's a patient with Medicaid, take them out. If you've got an account with a time payment plan and it's being paid correctly and on time, remove it. If you've got a patient in an HMO and they were accidentally balance billed because of the software, because that happens. I worked with a practice who had this software that basically was designed by accountants. It wasn't designed by anybody with knowledge of medical billing and medicine. What happened is once they entered the patient into the computer system, a clock started. It sent the claim out the door that very day or the next day. Within 30 days, if nobody worked the account, nobody went in and did anything on that account, it automatically converted that account from insurance responsibility to patient responsibility. Then started billing the patient or balance billing the patient, and then it sent the account to the collection agency. Everything was automated. So you got to be very, very careful with your software to make sure it doesn't do all this automation. You want to make sure that you go through and you fine-tune that account that you're sending to that collection agency. Make sure it is true bad debt. And again, work with that patient before you send that patient to your collection agency. We're going to now start the FAQ section of my presentation. I've got a few questions here that come up a lot, and I'm going to try to provide you with some answers. First question that's asked: we use a debt collection company. They invoice us for a large sum of money, and they don't provide any documentation to back up their invoice. When we ask, they say we don't need it. What can we do? Sound familiar? It should, because I brought it up earlier in this presentation right here. The answer to this, very simple. Like I said earlier, the collection company works for you, not the other way around. What I recommend, arrange a meeting with the collection agency to discuss this with them. Sit down and talk about the terms. And if you are not pleased with the result of that meeting, one of the things that you may have to consider is to terminate them and find somebody else. This is usually the results of the photographs, usually results of a lot of the meetings that I'm the one that's awake. You can see Don in the front right there, half asleep right there. So again, have a meeting to discuss this out. Communication is key to collections, no matter what type of collections it is. Second question: the billing company we hired also owns their own debt collection company. I brought this up earlier. Our patients are complaining that they aren't getting billing statements. They are getting debt collection notices instead. Can they do this? The answer is, with this, you might want to talk to your practice attorney, because you have no doubt signed a contract with that insurance company. Have your practice attorney go over that contract to see if this is part of the contract. If it's not, have a meeting with them to discuss this. Now, they're doing this because they get a higher percentage from collection than they do in billing. And again, always go back to your practice attorney and discuss this with them. And again, have a meeting with these people to try to iron out the problem. Maybe this is just a glitch in the system. The next question we have: since we hired a debt collection company, patient complaints went up 200%. This is my little cat Meepers that's on the screen right here. So some patients are coming to us very angry. The collection company says they're not doing any illegal. What can we do? The answer is very simple. Like I said, I put dummy accounts with my office address and my phone number in the file. This allowed me to see the statements that they sent, to listen to the calls that they made, and the patient may be right or the patient may be wrong. If the patient's right, sit down and have a meeting with the company and meet with the provider to find out what is going to take place. If they are wrong, discuss this with the patient. Again, communication is your key to debt collection, to collections, whether it be with the insurance company, with the patient, or with your debt collection agency. Last question. The patient owes us for their co-pays, deductibles, and co-insurance. The doctor wants to know if he can routinely write these off. This is a question that has been asked constantly over the last 20 plus years, and it has been asked in every way possible, every shape and form. The answer is very simple. Can you routinely write these off? The answer is no. And the clue is routinely. You cannot routinely write these off. It could be interpreted the wrong way by an auditor or an investigator if you do these routinely. The key thing is that each write-off must be done on an individual basis, and it must be documented why. There are 3 reasons that you can do a write-off, or what I call an adjustment. First is if the amount owed is less than the cost of collecting it. You don't want to spend $1 trying to collect a nickel. So if the amount that's owed is less than the cost of collecting it, then we do what we call small balance adjustments. But we keep an eye on that account, because if the patient came in for another visit and now what the patient owes is worth the cost of collecting it, and then what we will do is we will reactivate that account by reversing the adjustment, and then sending the patient a statement for the adjusted amount, including what the current amount is, what the past amount was. So that's what we handle with that. The provider has used all means to collect, which includes debt collection. That's when you can do an adjustment. The third one is that the patient is financially unable to pay. Find out if the patient meets the poverty threshold. And as you can see on this slide, I put down the website address where you could read what the poverty threshold is. I did not want to put it on the slide because it could be very, very boring, and I'm boring enough. So you can go to this website and look it up for yourself. What you want to do, if the patient's financially unable to pay, send the patient an application for consideration of a poverty adjustment, and then have them send that application into you, showing you their bank statements, showing you any pay stubs, showing you income tax reports. I had to do this with a couple of doctors when I lost my jobs several years ago, and I had no money coming in. I used up all of my savings to pay the bills, but I still had medical bills left over. So I contacted some, this is my situation. They sent me the application, one of my bank statements, tax returns, and all this other stuff. I sent them in, and then they sent me a letter that said, Mr. Verno, we reviewed this. We have found that you have met the poverty threshold, and we are doing an adjustment of your bill. Once you're able to pay, let us know, and we will see if we can't work with you to pay. I was financially able to pay them months later and work those debts off and paid them all over a little at a time. I owed $300. It took me 300 months to pay them off. So that's what you want to do right here. We've got 2 more slides to go. At this point, Don, I'm going to open it up to questions from the attendees right here. Don, you there? Hello? Everybody home?
I am.
Okay. I don't know how to open the floor up.
Well,
Yep. And this is Randy. I'm here too, but I don't know where Don is.
well, I think they have to do a question and answer, and then we read the question and you answer it. But I don't see any question or answers. But we
Right.
need to,
Exactly. We don't open it up on the voice. What we can do is the people can write in their questions in the question and answer area. I had mine muted and couldn't understand why you weren't hearing me.
You sounded good, Don.
Thank you. But no, we don't have any questions right now. I have a question for you though, Steve. The letter you have from CMS stating that if the patient presents without insurance and later says that they have insurance, Medicaid for instance, they're pretty much screwed. Do you feel comfortable sharing that letter in the PDFs mail outs that we're going to be sending out to all the attendees?
Yeah, what I'll do, Don, when this is over with, I will email you I have them scanned in as a PDF file or
Okay.
JPEG. I will send them to you and Jennifer. I think I've got Ranadine on my email list too. I'll send it to her. I have no problem in sharing it
Okay.
whatsoever. And you know me, anything I've got, I share.
Of course you do. Yes.
Except for my dog, my horse, and my guns.
And the narrow disease. We won't go there now.
No, that's fixed. It's covered by Medicare and my secondary insurance.
Okay, so also, just so that everybody understands, after the webinar, you're going to be getting an email with a link to a survey for you to complete. That tells us what you think of the webinar, whether or not, what areas you want us to make changes on, as well as what CEUs you're looking for. Okay, so we got some questions here. Steve, can you see the questions on your side, partner?
No.
Okay, down in the Q&A, you should have a Q&A little button down towards about by where you said you had to share screen. The first question, Jennifer Sunday. If we have a patient that has Medicare and no secondary insurance, but can't afford to pay it, do you think it's best to not bill Medicare as opposed to writing it off?
Me, I don't think it's best. If the patient's got Medicare, if the service is covered by Medicare, send the claim to Medicare, because Medicare will pay for all covered services. Now, if they've got if they don't have secondary insurance, but they've got their copay, or excuse me, they've got, let me slow down here. If they've got no co-insurance or at all, the amount that is left over, contact the patient and see if you can't work out a payment plan with them. But if they can't basically afford to pay that, then consider doing the poverty financial adjustment.
Exactly. And that poverty adjustment, by the way, people, you can use not just with Medicare, but it's pretty much standard in the industry. If you have a patient who comes to you and says, it's either electricity for the air conditioning or Alpo, one or the other, and that's my only choices, then I would not hesitate to pull out the form with the patient right there and then make an independent decision to waive that patient's co-insurance based upon your belief that that patient meets or comes close to the poverty guidelines. There is no law that says they have to be 14% of poverty, they don't have to be 125% of poverty. It's just, if you believe that it would endanger that patient, then you have the right to do so. Would you agree, Steve?
Yes, sir.
Okay, Anne Marie asked, if a patient has Medicare primary, Medicaid secondary, and the patient signs an ABN, are we allowed to bill the patient for the service since we don't participate with Medicaid?
I would be very careful on that. I wrote an article about this particular issue. You want a copy of that? If they want a copy of that article about the ABN is not to be used as a method of billing the patient. The ABN is to inform the Medicare patient before the services are provided whether or not Medicare will cover that service or not. And if Medicare won't cover that service, or if the claim is denied, it tells the patient how much they have to pay out of pocket in the event that there's a denial of the particular claim. That's what the ABN is supposed to be used for. It's not basically used to bill the patient.
Now, let me add something to that, if I may, Steve, and that is, when you have the patient sign the ABN, the amount that you're going to collect from the patient can be the Medicare allowed amount, or it can be your usual amount that you get from commercial, because Medicare's allowed amount no longer applies to the claim if Medicare denies it for medical necessity. Would you agree, Steve?
Yes, sir.
Okay.
And I would like to add, though, that you have to have that modifier for that ABN to show Medicare that you actually did collect an ABN so that Medicare can make a determination.
Exactly. Make sure you use a GA modifier on that.
Now, to add to that, you don't have that modifier on that claim, Medicare is going to send you the EOB saying you're not allowed to bill the member for the denied services. If you put that GA modifier, like Don said, on your claim form, then the EOB from Medicare will tell you that you are permitted to bill that patient. Okay, we've got a question from Joanne here. I don't know if you guys can see it or not.
They can't see it. We can, I think.
Okay, it says, Joanne, can you charge a collection fee to patients to cover the cost of placing in collections as long as it's written in the demo and they sign it? Basically, that's up to your state law. The reason I say that, in the state of Florida, we have these laws that basically are out there. Florida law says you cannot charge a patient a fee if you have not informed the patient ahead of time of what that fee is going to be. So no, you cannot charge that fee if you haven't notified the patient of the fee. Some practices are allowed to charge a collection fee if they have notified the patient of that fee ahead of time and the patient has agreed to the knowledge that they have to pay that collection fee. It all depends upon your state law. It also depends upon the contract you have with the doctor. It also depends on several other things. Some doctors have a contract that says you cannot charge the patient a fee. Some says you can, as long as the patient is aware of it. So that's going to be very, very important.
Emily has a good question there, Steve. Can please clarify if you're able to bill a Medicaid patient from another state?
Now, I don't understand if you're able to bill a Medicaid. You're able to bill that Medicaid patient. Basically, Medicaid's rules are you cannot bill a Medicaid patient for a covered service that's payable by Medicaid.
I don't
But
know.
that would not be payable to you if you do not have a provider number for the Medicaid carrier in the other state, though, right?
No, I asked the state of New York this particular question. What the state of New York basically told me is that if the service is covered by Medicaid, then my doctor has to enroll as a Medicaid provider in that state and then submit a claim to Medicaid for payment by Medicaid. I could not bill that Medicaid patient as long as the services were covered by Medicaid.
I think I would probably challenge that one with an attorney, and I'll tell you why. I can't believe that a state of New York law would apply to a doctor practicing in Florida or Texas or anywhere else. I would feel funny about that. What do you think, Randy?
I think she's got her mute on.
Oh,
I did. I'm just listening, but I'll defer to you guys on those kinds of questions.
I think I would ask an attorney on that one. I really would. I wouldn't trust the state of New York to tell me. Well, I wouldn't trust them on anything, come to think of it. Okay.
Well, I do because I was born and raised in New York.
Yeah. Okay. Jennifer asked, these are long-standing patients the previous office manager just wrote off after billing Medicare. I'm trying to tell them you can't do it, so I'm fighting with this provider to do the right things. Okay. The question is, if they do not qualify for poverty, but they still have no money, what do we do?
I think basically, Don, if this is going to be a decision on your part, right there, like Don said earlier. They got no money. They don't qualify for poverty. Like you got those that fall into the cracks right there. You got to make a decision on what you want to do. Follow your office practice financial plan. It could be to sit down and discuss this with the doctor. Say, you know what, doc? They don't make enough money to pay this bill. Maybe we just need to adjust this off. And then the doctor makes a decision, and that's what we do. There's several decisions the doctor can make. He could give the patient a discount to what they owe. The doctor could do an adjustment and write the whole thing off, or the doctor can set them up with a time payment plan. These are the three options that we used to offer our patients when they came into that situation.
Good questions, by the way. These are great questions. Any other questions right here? I don't want to get in trouble for Medicare fraud by billing Medicare and knowing I can't collect.
I don't understand what that means.
I don't either, unless she's sitting there saying she don't want to get in trouble with Medicare by waiving the patient's co-insurance. If you've sent that patient 3 statements and they say they cannot afford to pay you, but they don't qualify to get a poverty discount, you've already sent 3 statements. At that point, I would write it off. You've taken a reasonable attempt to collect that money. And reasonable attempt has never been truly defined by CMS or Medicare, from what I understand. Yes, I understand. Can you do that every visit? No, it's time to let that patient go, in my opinion.
Yep.
You cannot continue to provide services for free.
This is Randy, and I don't know about you guys, but we have financial hardship policies within our offices that we follow to do all of that. So they have to prove on the back end those kinds of things. And it's for previous balances incurred up to that point, not going forward forever.
Yeah.
And for those of you who are NHCLA members, in the members only section, the shared resources, we actually have copies of the financial hardship letters that you would give to your patients that give them the information that they need to follow, as well as the, I believe, website that Steve put on there for financial hardship. And as they both have mentioned before, Don and Steve, that it's kind of up to you whether you can figure out that these people are really having a hard time surviving.
Now, let me also take this opportunity to say that for those of you, because we have a lot of folks in here that came from AMBA, my website, and the newsletters and stuff, and other locations that are not NHCLA members, let me explain. NHCLA is an association of healthcare leaders, primarily the office managers, administrators, etc. But we have folks in here that's not in management itself, but they want to be. And membership is how much, Jennifer? Now would be a good time to tell everybody.
Well, I believe membership is $185 a year. You can apply for reciprocity for a CHM, which is a Certified Healthcare Manager certification. We also have a billing specialist certification, but we do these webinars as a benefit for free to the NHCLA members so that you have the ability to get your CEUs and have them for your recertification every year at no cost.
Excellent. And if people want more information on NHCLA, when we send you out the email, we're going to be sending you information about how to get to the website and how to enroll with NHCLA and some of the benefits. That'll be coming out in an email to all the attendees.
The website is www.nhcla, National Healthcare Leaders Association. So it's www.nhcla.com.
That's easy. Well, folks, if there's no other questions, I am going to say thank you all for attending today. I hope that you got a whole lot of information. We appreciate your participation with this program, and we appreciate Steve a whole lot. He's a good man. If you ever get down to Orlando area, I know I've enjoyed being a friend with him for many years. I think you folks love him as much as I do.
I'm down here too.
Yes, you are.
And Candace, you're very welcome.
And like I said, we'll be sending out an email to all the attendees.
Okay, ladies and gentlemen, thanks, Don. Thanks, Jen. If you guys got any questions, is there some help you need, contact Jennifer at the NHCLA or contact me through the listserv. I will see what I can do to try to help you out. We've got a lot of information that we can provide to you here. So until we meet the next one, I'm going to say thank you and farewell.
Thanks, everybody.
Thanks, guys.
Live long and prosper.